Now, I find this an interesting. I'm somebody who likes to observe the whole picture here, and I'm not sure why this picture of this large open space at obviously a large and modern shopping mall might be Mall of America in Minneapolis or another location. Why this was selected. However, perhaps it's because in each of these big shopping malls, in addition to the large anchor stores, almost all of which are corporations, so their stock can be traded, like a Macy's, a company like that. You see many smaller and boutique stores, and you see franchises. And so these are some of the issues that we will be discussing in Chapter 35 tonight. So we'll be looking at all of the different forms of business. Now, this particular chapter includes a discussion of franchises, and I'm going to talk about that a little bit. Also, joint ventures, because I would have included them in a different format, but we're going to talk about them as we get to them in this particular chapter in order to continue to follow this particular textbook, not confuse things for our participating students this evening. So this is a great start to this chapter in the news here, which can talk about the right business structure. It says can save you money and headaches. That is an absolutely true statement. And again, I've been a business owner for, I guess almost 50 years, and have been an attorney for over 40 years. And so I have been through many different business forms, almost every one that we're going to talk about this evening, although I've never purchased a franchise. I have acted as an attorney and consulted with people on many franchises. And in fact, I am working with a group of investors who just purchased their third franchise from a particular franchising company, and consulting with them on how they're structuring that. And they're going to structure the holding company for that third franchise as a separate LLC. Each of the other two franchises that they own, they have set up LLCs to acquire. So to give you a little bit of a taste of that. But let's talk for a few minutes about Black Cat Computer Wholesale. And it says they went through 3 different corporate forms in its first 5 years of operation. This is not unusual. This is actually kind of perhaps you could say a clear-cut success story. The computer wholesaling business started out as a sole proprietorship. And again, my observation is most businesses today and in the past have started as sole proprietorships. And so there's nothing especially unusual about that. And it's easy to set up. You don't need to go to the state and say, Mother, may I, and file and pay any fees. Now, there are some significant restrictions because in some areas, not so much in the greater Texas state, but in other states, there are very strict restrictions on business operations, and you have to purchase a business license. So there may be some other types of restrictions independent of your corporate form. As we use the term business organizations, often we say corporate form, even if we're not setting up a corporation. And so the sole proprietorship, I often refer to that as working off your dining room table at your house. And in fact, many businesses, many very large businesses today started working from your dining room table. Many of you may be familiar with the very famous computer firm Hewlett-Packard. Hewlett-Packard famously started in a garage behind one of the two named founders' houses, and they just started in a garage behind the house. And so this is a very typical situation, obviously a corporation listed on stock exchange today. And so after they got up and rolling, they realized the need to raise capital, which is difficult to do as a sole proprietorship, to have a more permanent form of organization, to have a system for the future. And so they did something that is typical of the past, not so much of the present. And that is they formed a corporation. And by the way, all for-profit corporations pretty much start as C corporations. And you say, but Dr. Shine, it says they started as an S corporation. That's actually not very accurate. When you set up a corporation, you set up a C Corp, a for-profit corporation. Then you file a separate form with the Internal Revenue Service, our buddies at the IRS, and you say, we are going to choose to be taxed as individuals and not as a corporation. That is the sub S election. And then as the corporation grows and you need to get bank financing and you want to have a broader selection of stockholders, you surrender the S election and switch to a straight C corporation. So these actually are part and parcel of the same situation. Now, in contrast today, what we see is they go from being on the dining room table fairly quickly to the LLC, which we'll talk about later in this chapter. And then from the LLC, it's a relatively easy conversion to convert the LLC to a C corporation. If you're ready to go public, you're ready to raise major bank funds, you're ready to sell shares of stock, the traditional corporation is the best fit for those situations. What do the LLC and the corporation have in common? Limited liability. And even though we have strong protection in Texas, and you may remember we've talked about this more than once so far in the course. We talked about this when we were talking about bankruptcy, and we said that the Texas Homestead Act is a very powerful protection for individuals, and it allows the individual to preserve their homestead where they live, to have it not subject to bankruptcy. They do have to keep the mortgage payments up. And also they get to keep a reasonable amount of personal possessions that are not obvious from a normal bankruptcy. But at the same time, it's extremely disruptive to anyone's life to be forced into filing a personal bankruptcy. So by forming any type of business organization, it puts that organization between you and liability. Now, I want to quickly add, and I think I've mentioned this earlier in the semester, the part of the issue here is, however, that if you have personally guaranteed things for your startup business, you're not going to get limited liability for that. So here's a classic scenario. You start on the dining room table, but very quickly you move to an LLC. You go out to rent some space in a shopping center or something to operate your business, maybe a franchise, maybe not. And then at that point, what happens is you decide to sign a 5-year lease for that space. The landlord looks and says, well, hey, your business hasn't even been in existence for a year. We are not going to let you just sign the lease as the managing member of this LLC, which has less than a 1-year track record. We're going to require the members of that business, you and any other members of that LLC, to personally guarantee that lease. So if the business fails and the lease is not honored, you will be responsible for that lease, even though the business was an LLC or a corporation. In addition, if you need to borrow money, young businesses, even if they're properly formed as LLCs or corporations, the banks are not stupid. They're going to require you to personally guarantee that money. If you're many small and startup businesses go through the SBA, the Small Business Administration. Small Business Administration is going to require you to put some skin in the game, as the cliche goes, meaning you're going to have to put up your own personal assets, not just business assets. So the effect of these things is a little bit less than it sounds, but it's still the right way to do business. And the kinds of things we talk about, you have a slip and fall in your business, that's your leasehold, and someone's hurt and they get those scabby-kneed attorneys that chasing the ambulances, go about suing everybody, and your business gets sued for that. And of course, you should have the best package of business insurance, but if it still goes beyond that, if it's a significant injury, it maybe exceeds your insurance limits, at least you have the protection of that business form, the LLC or the corporation. So with having said that, let's go ahead and take a look at some specific situations within this broad area of business organizations. So again, the big daddy is the sole proprietorship. It's generally one owner, maybe a husband and wife owner, but one owner. It's not taxed as an entity. The sole proprietor are liable to all the creditors. Everything that you do in the business, you are liable for, and that's its biggest risk. And it doesn't matter whether it's in contract or tort, you're at risk. Now, in a bit of a surprise here, they insert franchising at this point in the chapter. I would not have done this. And in other textbooks that I've taught from, franchising usually comes after all of the discussions of all the different corporate forms and business forms. Franchising is usually like a last chapter along with the joint ventures. In this particular textbook, they throw them all into chapter 35. So let's talk about franchising. As I mentioned, I've got an active client right now that's doing some buying franchises, and they're just buying their third franchise at the end of this month from a particular company, relatively young franchise, but one that's nationally known. And they are forming an LLC for each franchise that they purchase, which the advantage to that, folks, I want you to think about that strategically, means if one of the franchises fails, it doesn't take the other two down, because they are separate organizations. Also, because these folks are already up to their third franchise, the franchising organization is not requiring personal guarantees. So the LLC in this particular case is providing a margin of protection. Now, this is not an especially expensive franchise, and therefore they're not borrowing money from a bank, and they will be signing a lease. I am hopeful that they will have enough of a track record that they will be able to lease the property for this third franchise without personally guaranteeing the lease. And if I have some input on that, one of the things that we do is to have the lease guaranteed for only the first year. And the way we structure this sometimes with the cooperation from the corporate landlord is to say, if all of the lease payments are made on time during that first year, the personal guarantee goes away. That way, they've only guaranteed it for that first year, gives them that margin of protection. Again, some of these practical tips that I'm giving you tonight are not in the textbook, because the textbook is more of an academic exercise, but the reality of running a business is not an academic exercise. It's your life. It's your business. It's what you take home. It's how you support your family. So we want you to be thinking about the practical aspects of what we're doing here. So usually the franchises are fairly restrictive. I'm pretty familiar with McDonald's franchises. You can't even use paper napkins that are generic at a McDonald's. You have to use everything that is blessed by McDonald's. And because they are the big cheese in this industry, they are allowed to dictate all of the terms, including where you locate your franchise and things like that. But they are very good at it, and very, very few McDonald's franchises around the world have failed. Though an interesting case you might find is where McDonald's closed a franchise. There was an operation in France that was running a pretty lousy McDonald's operation. They were not following the franchise rules, and they were using non-standard napkins, for instance. The location was dirty, so on and so forth. And after giving them several warnings, McDonald's yanked the franchise. And there was a lawsuit that followed. And of course, McDonald's won and said, hey, it's a contract. We're in charge. We know how to make these very successful businesses. You didn't do what you're supposed to do. I did want to point out again, there's a little error here at the bottom. Franchising is regulated at the federal level via the Federal Trade Commission. This is a true statement only with regard to interstate franchises. So if a franchise is traded around the United States, then it is required to have a federal franchise registration with the Federal Trade Commission that discloses a great deal of detail. And then when you are looking at buying a franchise, you can access that particular report to make sure that you get the straight skinny on that particular franchise. Now, here in Texas, which is such a large state, I am familiar with a franchising company out of Dallas that only runs franchises in the state of Texas. They are not required to register with the FTC because it's all interstate. And they run a series of quick lube centers and car washes and dry cleaners, of all things. That's not a very compatible set of products, but those are 3 product lines. Again, they only operate in Texas. Now, this is the worst form of business ever invented, is the general partnership. And you might say, oh, Dr. Schein, doesn't seem that bad. It's just kind of a big sole proprietorship. Yeah, but it's not just a big sole proprietorship because of the word sole, S-O-L-E, is not in there. So this one is the state is not a party to the formation. Okay. Partnership's not a taxable entity. Okay. And then it says each owner has an equal voice in management. Nah, not really. It may operate in more than one state. I would be very surprised to see a general partnership that operated in more than one state. So I don't know why they threw that in here. The disadvantages are overwhelming. There's no legal limit on the number of owners, but there's a practical limit as to how many people you want running around. That means number 2 here, partnership is dissolved every time the partners change. So if you have the mythical general partnership, but do we cheat them and how, and how leaves, and you get another loser in there for the third partner, you now have a brand new partnership because it is specific to the partners participating in the general partnership. That can be a real disadvantage in itself. The next step, though, is the big one. Partner's liability is unlimited. The partner's liability is unlimited. So parallel to sole proprietorship, you say, well, it doesn't seem much worse than a sole proprietorship. Wrong, because in a sole proprietorship, you make the decision as to how much liability you want to have. In a general partnership, somebody else can create liability for you. So not only do you don't have control over all of your liability exposure, because you may have a general partner who's a real clown, goes out and spends money out of the partnership treasury to do business deals that you do not approve of, or to sign contracts that you do not approve of. And guess what? You're going to be stuck. So the partners are taxed on profits. And this can be a very difficult situation. Alfonso, go ahead.
What would be a scenario where a general partnership is preferable versus a limited liability?
None. There is not one I stopped setting up general partnerships 20 years ago because with the availability of the LLC, it makes no sense to operate as a general partnership. Now you say, well, Dr. Schein, why are we talking about them? Number one, because I want you to be aware of the negatives behind it. Number two is you can back into a general partnership. And it's really important to understand this situation well enough that you do not accidentally become a general partnership. And I think the next slide talks about that. Let me flip slides here. Yeah. Biker versus Maines, as an accountant and real estate professional, ran several businesses for profit per an agreement. They set forth expected performance. And then when the venture failed, the defendants denied the existence of partnership. The court looks at it and says, well, if it, quacks like a duck, walks like a duck, all that stuff. And this is the problem. So you need to be especially careful, especially if you're a sole proprietorship, that you do not accidentally become a general partnership and become liable for somebody else's misdeeds or mistakes. So that's why I want all of you to understand general partnerships. We'll talk about them in a little more detail in chapter 36 on Thursday.
I actually see general partnerships a lot. Being in mortgage, you see the tax returns. And so there's a lot, quite frequent general partnerships out there, surprisingly.
Yes, thank you. Well, and I can tell you, and you get involved with that as an accountant? Or how do you happen to come across them?
Well, I'm a lender, so I see it because it's usually we're having to look to see what we can actually use for income, because we can't use the whole business income. We have to see what percentage they own. And then that's how we get involved to, go over the details of the finances.
Very good. And so, yeah, I'm not trying to maintain that there are no general partnerships out there. I'm just saying it's a pretty stupid form of business. And like I said, I stopped setting them up 20 years ago. That doesn't mean that they aren't still out there. And again, sometimes people back into them. But when I'm contacted, I do my very, very best to persuade people not to, to go ahead and move to, at a minimum, the LLC, which is so flexible and so easy to set up. But some people still do it. And you just described one of the other many downfalls, which is you need to look at each individual partner and their income tracing and things like that to see how substantial they are. But at your lending institution, will all the partners be jointly and severally liable for the loan, or are you allowed to allocate the loan liability across the several general partners?
Well, I'm in mortgage, so it's just the single family homes that we deal with, So if I was on the business lending side, it would be different, But so when we look at the tax returns, we're really just looking to see how much income we can use for that individual partner.
I gotcha. Okay, so what you're saying is you have an applicant for a mortgage who happens to be participating in a general partnership, and you have to examine the general partnership to see what their potential income from that is. What about their potential liability?
Same. So it just depends. So we have to look at it as a whole. So we, I don't know, some people out there are used to it. So we'll use a SAM or whatnot to calculate their income, and it looks at their receipts, and it takes out their liabilities and things like that, and it gets the bottom line for what we can use. And then from the bottom line, okay, well, there's a percentage. Usually it's 50%, or if there's multiple partners, 30%, 33, or something like that. Mm-hmm. So it'll just depend.
That's super. Thank you for that input, Vanessa. I appreciate it. And let's see. Do we have another question out there? Okay, let's go ahead and move to the next slide. And again, I'm surprised that they inserted at this point in this chapter, because I would usually do these at the end. But it makes the joint venture sound like it's a combination of, it says 2 or more persons, and it makes it sound like it's a combination of 2 sole proprietorships. And actually, joint ventures are relatively specific. First of all, you can have 2 corporations or 2 LLCs engage in a joint venture. There's nothing that said it has to be 2 people. And joint ventures are one of the preferred ways to enter international commerce. And a company in the United States may form a joint venture with a company in Colombia. And the company in Colombia provides the boots on the ground and the local contacts. The company in the United States, the other joint venture, provides product, name identification, maybe capital. So those are very common uses of a joint venture. Not a lot of this with 2 individuals. So I'm not happy with the way they formatted this particular slide. It says agree to share the profits or losses jointly. That may be true, but that doesn't mean 50-50. And a lot depends on the size of the prospective businesses. It says it's less formal than a partnership. I disagree with that. Most joint ventures are going to be formally written documents by the attorneys involved, and that's a particular art form is writing good joint venture agreements. And one of the things I wanted to mention is a great example of this was before I left Richmond, Virginia, to move to Houston in 2013 to teach for the Cameron School of Business. The city of Richmond, Virginia, decided to replace its old obsolete jail, which is right in the downtown area. It sits behind the city courthouse, actually behind City Hall. And so they put out some bids. They said, well, we're going to allocate $50 million for a new city jail building. It needs to meet all these specs. And this is what you're going to do. You're going to tear down the existing jail, build a brand new jail on that site. We're going to have to park the prisoners and the activities in another buildings on a partial basis. So we want this to be done on a very quick basis. And we'd really like to have a local construction company. Turned out there was not a construction company in the greater Richmond area that could take on a $50 million project. What happened, though, was two successful smaller construction companies formed a joint venture solely for the purpose of bidding on and building the new City of Richmond jail, and they got the contract. That is a great example of a joint venture. A very specific project with a specific time frame, and each of those two construction companies put in their expertise to get the contract. So those are the types of things we want you to think about. And I don't know if they formed a corporation of the joint ventures or if they simply acted as a partnership of corporations, but both the construction companies were corporations. And it says joint venture terminates upon the conclusion of the event or project. That's a judgment call. It depends on how the project is structured. So again, some of this stuff tends to be a little too simplistic versus what happens on a day-to-day basis. Now, limited partnerships used to be a much bigger deal than they are today. And as correctly described here, hybrid between partnership and corporation. Now, this is a very popular question on standardized testing as to the definition of a limited partnership. So I'm going to specifically say this. A limited partnership is composed of one or more general partners and one or more limited partners. And the idea behind it is the general partner has unlimited liability. The limited partners, as long as they stay out of the business, have limited liability. Basically, they only stand to lose the investment, the money they paid into the limited partnership. They don't stand to lose any beyond that. Now, I mentioned the fact that they do not take part in running the business. I acquired my current property, in fact, where I'm sitting tonight at my office on Heights Boulevard. I acquired this property through a limited partnership. We formed a limited partnership specifically to acquire this building. Within about 8 months, I bought out my partners. Why did I buy out my partners? Because I couldn't get one of them to stop taking part in running the business, and he only held a minority share, but he acted like he owned 100% of the place and was full of all useless advice. And so I found it was easier just to go in and buy him out. We liquidated the LP, the limited partnership, and I took over as a sole owner. So, but for many, many years, decades, the way to acquire a building frequently was a limited partnership. Now you say, well, what about that old general partner? Aren't they going to really take it in the shorts if they're not protected? And you say, well, number one, you always want to buy insurance to cover as much liability as you can. That's number one. Number two, something that you might not have thought about is the general partner can be a corporation. So when I had the limited partnership to acquire my Heights property, we set up a corporation that had no assets to be the general partner, which meant if the whole thing blew up at some point, literally, not figuratively, then the general partner would take the hit. The general partner had no assets. So it wasn't going to be that big a deal. And then the limited partners, of course, were the several of us who had financed the venture originally and obtained the original mortgage. So what has happened is the limited partnership is still out there. It still works to acquire businesses, although again, it is usually used to acquire a specific piece of real estate. Is the LLC, again, is so flexible that a lot of people are using the LLC to acquire individual pieces of real estate rather than forming limited partnerships, which are more complicated to set up because of the parallel system of a general partner and then limited partners versus just setting the LLC up. And so this is where that trend line is going with the LP. Now, we're going to switch gears to the corporation. And again, for larger businesses, for raising stock money via stock sales, even for going into your bank to borrow money, the corporation tends to be the gold standard for that. And so it's the easiest way to raise capital. The tax laws may provide certain protections. Control can be invested with a minority interest. So there's lots of shareholders out there, but there's certain people just have control. And of course, importantly, the investors have limited liability. And the corporation creates liability in contract or tort. It's on the corporation. It's not on the stockholders. Now, again, keep in mind that if you have stockholders who are running the corporation, in other words, they're wearing two hats, they're officers and they're stockholders, they have limited liability as stockholders, but as officers, if they violate federal laws or violate securities laws or commit fraud, again, classic example, the Enron, which was right here in Houston, then they do not get limited liability for their criminal acts. So, but again, the stockholders themselves are usually in a pretty safe position. And then, of course, corporations can exist on a perpetual basis or permanent basis. Why would you not do one? Well, it costs money to form a corporation. The paperwork here in the state of Texas, it's easy to set up the corporation, but then you've got to do a separate tax return for the corporation. You've got to file paperwork with the state of Texas every single year, and you need to file what's called a franchise tax form, franchise being the permission from the state of Texas to have your corporation. One of the most significant disadvantages to having a corporation is what we call double taxation, which is the second bullet here. So what it looks like is, say your corporation makes $100,000. They will file a tax return with the Internal Revenue Service, and they may pay, say, under the new tax laws, 22%. So they pay $22,000, and then the remaining $78,000 is paid out to the stockholders as a dividend. When the stockholders get their share of that $78,000, they will need to declare that dividend as an income and then pay taxes a second time on their income. So it is a bit of a challenge under those circumstances because of the non-deductibility of dividends as a cost of doing business. Now we'll talk about a little loop on that in a minute. But one of the things is that a corporation needs to be qualified to do business in each state that it does business in. And this tends to be a little tricky. So we're here in far East Texas, not quite to Beaumont, but we're in Eastern Texas. We're near Louisiana. So a number of the companies that I work with have operations or facilities in Louisiana. What that means is even though they're in the neighboring state, they need to be qualified to do business in Louisiana because they have active operations over there. And then there's a benchmark. Certain things you can do in another state without being authorized in that state. But then there's a certain cutoff where it's like, well, boy, you've got a fixed office, you've got regular employees over there, and it's starting to sound like you better have registration in that state. It doesn't require you to set up a new corporation at state, just to be authorized or qualified to do business in the states where you conduct business. And of course, you've got to deal with more government red tape. Now, how can you avoid double taxation? Now, I know we have a number of accountants on our call tonight. And of course, one of the ways to do that is to pay reasonable salaries to the owners of the business. And the challenge to doing this is, if how do you know that the payroll is reasonable? We're going to look at a slide in a minute that addresses that issue. And then interest on loans is deductible as expense of the corporation. That is another way of reducing the income of the corporation. And then in terms of paying dividends, many of the new type corporations pay no dividends. The Microsofts of the world were set up to say, we are not going to get into the dividend payment. So a lot of your old style businesses, the Fords and the IBMs and some of the big long-standing corporations, part of the reason people wanted to hold what are called blue chip stocks is to get that paid dividend. But some other corporations do not pay dividends. In fact, I know, I believe it's Apple Computer, a lot of people came forward in the last few years and said, you know, you've got so much cash on hand, even if you have a policy against paying dividends, isn't it time to start paying dividends if you're not going to dramatically reinvest that money and make our stock, if you don't improve our capital value of our stock, capital gains tax, then you need to start paying dividends. So I don't know how that's turned out. I don't track the Apple stock, but I know it's one of the high flying stocks. And then another area which we talked about in one of our opening slides is you can form a sub S corporation, so it's taxed as for individuals. Now, part of the deal is it used to be in the old days that you could flip your sub S. You could be sub S in some years and not sub S in other years. And I'm not sure the exact year of this. I think it's at least 15 years ago. The IRS came forward and put out a notice and said, hey guys, you can't do that anymore. If you go for a sub S, that's fine. And again, usually it's done while the business is in the formative development stages. Once the business reaches a certain size, turn that switch and goes back to a C corporation and stays as a C corp. So just so you're aware that you are allowed to make the S election, but it is not as flexible as it used to be. And what do we know about a subchapter S corporation? It's limited to 100 shareholders. By the way, that used to be limited to 35 shareholders, and it's still limited to one class of stock. Now, what happened here was the old limit was 35 shareholders, but the reason it was increased to 100 is because of competition from the LLC. So because so many small startup businesses went with the LLC, just to even have a lot of businesses participating in the sub S, they made it a little easier to participate. And there are a number of restrictions on those shareholders. So as far as I know, I believe international shareholders, non-domestic shareholders are still not permitted. There's certain other information involved in it. And one of the risk factors, if you are a shareholder, is if the money is not distributed to you, it's held in to maybe do more development, you may be asked to pay tax on something that you never got to spend. No, they didn't give you the money, but you get the tax liability. Usually that's not a large hit. And the incentive is to say, well, I want that corporation to keep growing because I want to have more capital value. Now, the other thing is, of course, is you're getting the money as income distribution, investment income, and that is not subject to self-employment or payroll tax. It's not earnings income. It's an investment income. Now, this is a great example of what we were talking about a few minutes ago about having the salary inside the business to meet a particular standard for the IRS. So the the accountant pays himself only $24,000 in salary, which is of course subject to the employment taxes, and then takes out $200,000 as his equity distribution. So the IRS gets involved in this case, and they hammered Watson here for $91,000 a year. So his employment taxes were underpaid. And again, these type of situations are relatively common. And I kind of stay out of it. Again, I know we have some CPA candidates or CPAs on the line with us tonight. And that's your business as to how much is a reasonable amount to take out as salary versus taking out the rest as a profit distribution in a sub-S corporation. And again, this question is coming up less and less as people are moving to the LLC format. And so again, you need to think of the different questions that the court considered and how much time was spent, comparable salaries for other people, and things like that. And of course, the court is thinking of setting a standard so that if you, a CPA or an accountant, is helping somebody prepare taxes, you can provide competent advice on how much needs to be identified as compensation and how much can be taken out as earnings of the sub-S business. Now, we then get to the prime subject here, the limited liability company. The advantages: the owners are shielded from company debts unless they're held personally liable. We talked about this earlier this evening because sometimes it's hard with a startup to borrow money or to sign a lease without being personally liable. And that's what they're addressing in this first bullet. You tax as a partnership, which means you tax as the money comes to you, not through a double taxation system. And they're very easy to form in virtually every state. Now, this first bullet is simply incorrect. They had it in the 5th edition of this textbook. I don't know why they repeated it, because LLCs have been around for 20 years. There's plenty of solid case law. So this first bullet is simply incorrect. And the second one is assume the members will work well together. This is a continuing issue, but one of the things I want to underscore with regard to this is that one of the problems that we have with LLCs is, since they're so easy to set up, people do the state paperwork, get it set up, but they do not agree on an operating agreement. How are we, the members of this LLC, going to work together? How much salary will we each take out? How much will we share if the LLC loses money? Things like that. So it's very important for businesses to be able to have the understanding as they go in, so that you don't destroy the LLC. And I'll tell you a true LLC story from a few years ago. I was working with a small construction services company in Virginia. And it was formed by 3 fellows. They did exactly what I just said. The LLC is easy to set up. They set it up themselves, no attorney involved. And they came off and got very successful very quickly. These 3 owners, these 3 members, were making about $25,000 a month profit within a year. And so that was very substantial. And the problem is that they couldn't agree on how to take the money home. So there was one older member, and he wanted to keep the money in the business, buy more advertising, put more development in, and to make the LLC bigger and more prosperous. The problem is that his 2 other members were much younger, had families. They needed to take the money home to pay their mortgages, pay their kids' schooling, feed the kids, stuff like that. And so they needed the money to come home. So there was this friction between the 3 of them as to what to do with the money, because they had not agreed to a written operating agreement before they started the business. And of course, they didn't anticipate it would be so successful. So I sat down with them. I helped them prepare an agreed operating agreement. And what happened instead, they never signed the proposed operating agreement. but the two younger men bought out the older gentleman. So then the two members, at least the two remaining members, had a common interest as to how to run the business and how to take money out of the business. The next thing that I heard down the road, a few years down the road, was that they split the business. They apparently had a couple product lines that they were able to separate. And so one person kept some of the product lines and the other person kept some of the product lines, but they did not continue in the LLC format. So that kind of underscores this last bullet is that in an LLC, it is important that the members work well together.
Question.
Sure,
Can you
go
just
ahead.
buy somebody out at any period of time? Like how, not like, I know we don't need to go into, I'm sure you could really have a class session on this, but as far as like just buying people out, is that just, you have the money and you can buy their shares and that's cool? And how does that really work?
Okay. We're going to talk about this in our next class meeting on Thursday, but let me give you the hot tip today in the right answer. Every business organization should have a buy-sell agreement. So when I don't write operating agreements for LLCs anymore. And the reason I don't is because I'm so tied up at the university that I just don't do enough LLC operating agreements to make it financially effective for me and for the client. So I refer them to attorneys that do them all the time. But in a basic operating agreement, one of the most critical pieces in that agreement is the buy-sell. And it spells out exactly how one of the members can get out of the business if they choose to. And I had another situation, which I'll share with you now, where there were two women and a man, another 3-person LLC. The business was very successful, right? This one was right here in Houston. And this one had a much better operating agreement. And so what happened was one of the women was involved in multiple family businesses that were very successful and had taken off. And so she said, I am going to sell out. And per the terms of the operating agreement, either member of the other two members could buy half of the interest or all of the interest. Well, what happened was the other female member of the LLC declined to buy all or part of the other first woman's share. So the man who was in the LLC did that. So he ended up owning 2/3 of the interest in it, and she ended up with 1/3 of the interest. And of course, the other member was gone. The next thing that happened is that because the person who apparently, by the way, was my client, was the one who controlled 2/3. That's when he got me involved, is when he got into a conflict with the minority member. And she, unfortunately, very sadly, had a serious alcoholism problem. And when it came to a head, the clients of the organization came to him and said, we cannot allow Miss Jones to be our client contact. You can have anybody else in your firm work with us, but we will not work with her because we do not trust her due to her obvious disability due to alcoholism. So what happened is that the lead member, my client, terminated her employment, and I was directly involved in that. And what happened was the way the operating agreement was written, if she was no longer an employee of the LLC, she could no longer be a member. And what that triggered was a forced buyout by my client, and the forced buyout spelled out a 3-year payout. So my client fired her, got her off the payroll, took her interest, and the value of that interest was calculated at that point in time by an agreed formula that the accountants agreed on. And then that was then paid out over the next 3 years. So that is how it was handled. But notice the way it was handled. The operating agreement had very specific terms, as to what to do in those situations. Required current employment to continue to be a member, and spelled out the member buyout. But that's the answer. And that answer also applies in corporations and other organizations, usually smaller corporations, because in big corporations that are publicly listed, usually there's so much stock distributed that it's just not the issue that it is with closely held corporations and LLCs. Did I get your question answered?
Yes, sir. Thank you.
Okay. Like I said, it's just you got to plan ahead. And believe me, it's so sad to see people fight to the death on some of these limited partnerships and LLCs where they have not planned in ahead. I saw another business where the two parties spent tens of thousands of dollars in legal fees fighting about ownership of a particular successful entity. And there was absolutely no need for it, but they had formed it without agreeing in advance as to how they would resolve the ownership. And so it ended up being a very brutal court battle, which eventually settled, by the way, once they'd spent a bundle of legal fees, each one of them. But it was an interesting situation. And then it talks about a dissolution for two in a limited liability company operated by two ophthalmologists. And that's where the value of having these buyouts. And in fact, the case that I just mentioned where these two spent all this money to resolve the ownership were both dentists, in this case, ophthalmologists. So it's real life in the situation. So why are we concerned about selecting the appropriate legal form for the different organizations? We want legal capacity. We want to be concerned about taxation. We want to be concerned about liability. And we want to be concerned about control. And then again, all of these require a good analysis so that for each planned organization, you need to look at the shell that you're working with, the system that you're working with. And sometimes some of these deals involve, as we talked about, multiple organizations being set up. Like I said, my client that owns now up to 3 franchises, they now have 3 LLCs, one for each franchise. These are designed to be small, very closely held organizations. The LLC works well. Now, if you've got the latest and greatest internet phenomenon, and you're going to have, 2 million viewers in the next year or two, then you may want to have a corporation so that you can go out and sell stock, raise money, distribute your ownership so that you don't have all of your eggs in one basket. So again, those are the type of things you need to think about to make the organization fit the particular situation.